Think about this for a moment. You are the absolute expert on your child, their likes, their fears, their routines, their dreams. You know it better than anyone on this planet. And your love for them? It's a force of nature. Planning for their future, especially when that future holds unique challenges, is one of the most loving and courageous steps you can take as a parent. But there's a problem most families run into. A gap. A dangerous gap in the plans we make. And today, we're going to close that gap together. Here's something that stopped us in our tracks. According to the ARC of the United States, nearly half of adults with intellectual and developmental disabilities rely primarily on a single parent for care. And here's the part that's truly alarming. Nearly 75% of those parents have not made a long-term plan for when they can no longer provide that care. 75%. That's 3 out of every 4 families. That's what we're tackling today. Hey everyone, and welcome back to the 3 Koi Fishes channel. We're a team of parents with over 80 years of combined experience navigating the real challenges of raising kids. We personally research and vet material, sharing the most relevant insights based on our practical knowledge as parents. So if you're wrestling with these difficult questions about your child's future, you're in the right place. We're in this with you. Now, before we dive in, a quick but important note. Every family situation is different. What we're sharing today is a starting point, a way to help you understand the tools that exist so you can walk into the right conversations prepared. But when it comes to setting this up for your family, you'll want a special needs estate planning attorney in your corner. Someone who knows the specific laws in your state. Think of this video as your roadmap. The attorneys are the ones who help you build the actual road. Now let's talk about something called a special needs estate plan. Here's why this is so important. For our kids with autism or other developmental disabilities, traditional estate planning, like simply leaving them money in a will, can actually cause them to lose essential government benefits like SSI and Medicaid. Why? Because those benefits often have a strict $2,000 personal asset limit. That means if you leave your child $50,000 in your will, thinking you're helping them, you could actually disqualify them from the health care and income support they depend on. Sounds scary, right? But here's the good news. There are legal and financial tools designed specifically to protect their quality of life without disqualifying them from that critical support. Let's break down the key components you need. Think of this as the roadmap for your child's seamless care. Key point 1, Special Needs Trust, S&T. The first tool is called a Special Needs Trust, or S&T for short. Think of it like a legal container. It holds assets, money, your house, investments, for your child's benefit. But here's the key part. Those assets inside the trust are not counted towards that $2,000 limit. This means you can provide for the extras. Therapy, specialized equipment, social activities, even a comfortable living situation. All while your child still receives their crucial health care and income support. Now, there are different types of trusts, but for planning with your assets, you almost always want what's called a third-party S&T. This is a trust funded by you or other family members, not your child's own money. And why does that matter? Because unlike some other trust types, a third-party S&T has no Medicaid payback requirement. That means if your child passes away, any remaining money in that trust goes to their siblings or other family members you designate. It keeps that legacy in your family, not returning to the state. Key point 1.1, the trustee. But who manages this container? That person is called the trustee. And this is a decision that requires serious thought. You can name a trusted family member, someone who deeply knows and loves your child. However, some parents find that combining family and finances can create conflict. That's why others choose a professional trustee, like a bank or a specialized attorney. They handle the complex legal rules, make sure everything is used correctly for your child's benefit, and can take that burden off family members. It's about finding the balance that works for your family. Okay, so we have the container. But a container is useless if it's empty, right? So let's talk about how to fill it. Key point 2, funding the trust. This is the financial engine of your plan. You need to strategically decide what assets go into that special needs trust. One of the most common and effective tools? Life insurance. Specifically, many parents use what's called a second-to-die life insurance policy, also known as a survivorship policy. Why this type? First, it's often cheaper than individual policies. And second, it only pays out after both parents have passed away. That means it provides a substantial lump sum precisely when your child needs that financial support the most, when neither parent is around to provide care. It can ensure the trust is fully funded to maintain their quality of life, long term. Key point 2.1, Beneficiary Designations. And this next part? This is a critical check you need to do right now. Even before meeting with an attorney, check your beneficiary designations, your 401k, your IRA, your life insurance policies. These accounts all have beneficiary listings. You must make sure they list the special needs trust as the beneficiary, not your child directly. Because if money goes directly to your child, it counts towards that $2,000 limit. And you're right back at the problem we're trying to solve. So here's your action step. Get a pen. Make a list of every financial account you have. And double-check those beneficiary designations. By the way, if you're finding this helpful, tap that subscribe button so more parents can find these resources. It really does help. Key point 3, Able Account 529A. Okay, the S&T is for the big, long-term financial picture. But what about day-to-day spending? That's where an Able Account comes in. You might also hear it called a 529A. Think of this like your child's own spending money bank account, one that works alongside their benefits. The growth and withdrawals are completely tax-free as long as they're used for what's called qualified disability expenses. That can cover rent, technology, transportation, educational expenses, even food, though you'll want to be careful with SSI rules there. And here's what makes this really special. If your child is able to manage some money on their own, they can have their own debit card linked directly to this account. It's a huge step towards independence. And that matters. 2026 Able Account Updates. And parents, pay close attention to this. The 2026 updates make Able accounts even more powerful. The annual contribution limit has increased to $20,000, and the age of onset for eligibility has expanded all the way to age 46. This means more families than ever can now use this tool. Key point 3.1, S&T versus Able, quick comparison. Let's do a quick recap so this is crystal clear. The Special Needs Trust handles the unlimited, long-term legacy, things like housing and major assets. An appointed trustee manages those decisions. The Able account, managed by your child or a guardian, handles up to $20,000 per year for daily living and immediate needs. It's about having the right tool for each financial job. Now, everything we've talked about so far is legal and financial. But there's one more piece of this plan that might be the most important of all. And it's not a legal document. Key point 4, Letter of Intent, LOI. The Special Needs Trust is a powerful legal document, but it's sterile. It doesn't capture the magic of your child. This next piece is the care manual for their life. It's a non-legal, but incredibly important document called a Letter of Intent. This is where you write down everything a future caregiver, guardian, or trustee needs to know about your child. Their daily routines, what time they wake up, what their morning sensory preferences are, their sensory triggers, what noises agitate them, what helps them feel safe, their favorite foods, favorite movies, the hobbies that bring them joy. You list their medical history, their favorite doctors and therapists. You clearly state your hopes for their living situation, whether you dream of them staying in a group home near family or having their own supported apartment. This document, updated yearly, gives that future support system the cheat sheet to continue your loving, personal care. It bridges the gap between a legal plan and the irreplaceable knowledge only a parent has. Key point 5, Guardianship Alternatives. Now, for many families, when their child turns 18, the instinct is to go straight for full legal guardianship. But here's something many parents don't realize. Full guardianship removes many of your child's civil rights, including the right to vote, marry, or make their own medical decisions. The good news? There are alternatives that protect your child while preserving their dignity and autonomy. Options like supported decision-making, where your child makes their own choices with guidance from trusted people. Or a limited conservatorship, where a court grants authority only over specific areas where your child truly needs help. Or a power of attorney, where your child voluntarily grants someone the legal power to act on their behalf. The right choice depends on your child's abilities and needs. But the point is, you have options beyond all or nothing. Key point 6, your action steps. Okay, let's bring this all together with your action steps. Step 1, Start that letter of intent. Today, even if it's just bullet points, write down what your child needs to feel safe and loved. Step 2. Check your beneficiary designations on every financial account. Make sure nothing goes directly to your child. Step 3. Look into opening an ABLE account, especially with the expanded 2026 rules. Step 4. Consult with a special needs estate planning attorney about setting up a third-party special needs trust. Step 5. Explore guardianship alternatives before defaulting to full guardianship. You don't have to do all of this in one day, but taking the first step, that changes everything. Now, we want to be really honest with you for a moment. Everything we've covered today, the trusts, the ABLE accounts, the guardianship options, these are powerful tools, but they need to be set up correctly. And the rules? They vary from state to state. A general estate planning attorney might not be enough. What you want is someone who specializes specifically in special needs planning. Why? Because one wrong detail, one beneficiary designation that wasn't updated, one trust clause that's worded incorrectly could undo everything. So, how do you find the right person? Start by searching for a special needs estate planning attorney or an elder law attorney with special needs experience in your state. Organizations like the Academy of Special Needs Planners and the National Academy of Elder Law Attorneys have searchable directories. Our job with this video is to point you in the right direction so that when you sit down with that attorney, you already know the right questions to ask. And that puts you ahead of most families walking in on day one. Conclusion. Here's what we want you to take away from this. You are not alone in this. And the fact that you watched this entire video tells us something powerful about you. You are a parent who plans, a parent who prepares, a parent who refuses to leave their child's future to chance. And that is the greatest gift you can give them. If you found this information useful and want other parents to know, please hit the subscribe button to help grow the channel. And please share your thoughts and experiences in the comments below. Thanks for watching, and we'll see you in the next video.